started each week with a joke courtesy of law and science, the interface between the law and science. I want to tell you just a little bit about Amy's background. She's an assistant professor actually in both the College of Law and the College of Media, and she primarily researches areas of freedom of expression in the First Amendment. She has a book that's coming out next year, The Legalization of Academia. It explores the growing resort to litigation in academic controversies and implications for academic freedom. I'm going to read that book so I can know exactly what I can say and what I can't say without getting in trouble when I teach class.
And I could sue you right now. I'm just kidding.
So anyway, she's actually written a number of articles for law review journals, and also many of you already recognize the name and the face, both from NPR, the local newspaper. She writes legal issues in the news that appears in the Champaign News Gazette every week. She also hosts a television show on the local television, which is, what's that one called? Illinois Law on WCIA, which airs on Sundays. And so she's very multi-talented, and we really appreciate her kind of coming to tell us maybe about how law will interact with science. She actually has a background in television and journalism, anchoring newscasts, before she actually was here to teach at the law school and continue some of her outreach efforts through the newspaper and radio. So it's really a privilege to have Amy come and talk to us, and without any further ado, Amy Gajda.
Thank you all, and thank you much for being here. I know it's snowy outside, and I could barely get out of bed this morning, so I appreciate you all being here very much. I also want to give my thanks to Inga for inviting me to be here. My family has come to these lectures on Saturdays for a number of years and have really enjoyed them, and so I'm delighted to have been asked to be a part. Okay, so as you probably surmised then from that introduction, I am a lawyer. In fact, I've been a lawyer for more than 20 years now. I'm not as buff as this fellow, and I don't walk around holding the scales of justice. But you might think to yourself, well, what does law have to do with science? Who invited the lawyer to the physics lecture? We know it's Inga, but that's another story. I'm going to explain a bit about that this morning in various ways. First, I'm going to tell you a little bit about my experience in law and some of the work I did that's science-related. Then I'm going to tell you a little bit about science in law and how sometimes the law just doesn't get science right. And then for people out there who may be thinking about combining the two in some sort of career, I'm going to talk to you about how to go to law school and also how to tailor your interests in law school toward doing something that's science related. Okay, so you might think of lawyers, and this is fairly typical, even first-year law students think this. When you are a lawyer, you spend a majority of your time in a courtroom arguing cases, generally about the guilt or innocence of a criminal defendant. And as you can see here, there's a lawyer arguing a case in front of a judge and a jury. Looks like the fellow wearing what appears to be some sort of hospital garb is the defendant in the case. And so this is what a lot of people think of when they think about lawyers, but that's actually wrong. We don't spend very much time at all in the courtroom, other than perhaps in arguing cases to a judge alone, and so I'll tell you a little bit about what life is like for a lawyer, and it's not this certainly all the time. What does a scientist do? Well, those of us who are not scientists probably think that they are men and women who show up for work each day in lab coats and place little things in glass tubes that promptly bubble over. That's my impression. You can tell that they spend so much time in a lab that they never see the light of day. So you might think that the two professions then never really meet. That lawyers are too concerned about guilt or innocence at trial, and that scientists are too concerned with Bunsen burners to care very much about law. But you would actually be wrong. Science plays an awfully big part in many legal cases, and so I'm going to start by telling you a little bit about my experience then working as a lawyer and some of the cases that involved science I worked on. I spent the first part of my career working in Washington, D.C. So I was a litigator in Washington, D.C. Litigators mean what we do is we argue cases in front of judges. So we argue something called motions in front of judges. Occasionally we might argue a jury trial, but I'm admitted to practice in Washington, D.C., Virginia, and Michigan. I've taken those bar exams, and we'll talk a little bit about that later for those of you who may be interested in becoming lawyers. I want to go through sort of what law practice means first so that you get a sense when I tell you about some of the cases involving law and science, that you better understand what people like me do. Or did when I was in law practice. And I want to start by telling you a little bit about a case I worked on when I was a lawyer practicing in Washington, involving a woman with something called Prader-Willi syndrome. Does anybody in here know what Prader-Willi syndrome is? Please raise your hand if you do. Okay, I don't see any hands. And that was me too. I had no idea what Prader-Willi syndrome meant. But what the case was a woman who had Prader-Willi syndrome who was in a group home in outside of Washington, D.C., run by my client. She sued my client for violating her First Amendment rights in various ways, including not taking her to church regularly. So she argued that this was a violation of her First Amendment rights. In order for me to better understand what Prader-Willi syndrome was, because as it turns out, many people with Prader-Willi syndrome lie. So that was important for me to know as a lawyer, that when I interviewed her, when I deposed her, I would know that she may be lying in response to my questions. Prader-Willi syndrome is a syndrome that affects whether or not you feel full. And so people who have Prader-Willi syndrome will never feel full. And so they eat all the time. And you may think to yourself, well, I have that, I know I do. But it's actually a very serious syndrome, so serious that people will die from obesity in their teens, because they will go out on the street and they will eat food from garbage cans, they will beg for food, they'll steal for food, and so in the group home my client ran, they would have to lock the refrigerators. So it was very important for me in that case to understand what Prader-Willi syndrome was. More importantly, it was, well, perhaps as important, I should say, it was important for me to know what cases had been decided before involving Prader-Willi syndrome and involving First Amendment claims based on freedom of religion and group homes failing to take people to church on Sunday. Because the way law works is we take a new set of facts, the woman with Prader-Willi syndrome, and we find existing law, and we apply that law to the new set of facts to try to argue before a court to dismiss a case. And that's what I set out to do. I set out to dismiss the case before we got to a jury, her First Amendment claim. So I didn't want to go to a jury. What I wanted to do was dismiss the case immediately to get rid of it. And so in order to do that, then I had to research both medical information and law. The first thing I did then was after I did that research, I wrote something called a memo to my client. I had to explain to the client what the likelihood was that the group home would win this lawsuit. And after doing all the legal research, I came to the conclusion that it looked pretty good. So I wrote up a memo for the client explaining, I don't think she has a case here. Here are the reasons why. Here are the legal reasons why she doesn't have a case. And they included some of the medical manifestations of Prader-Willi syndrome, including the lying. So I wrote that up in a client memo. After that, you have to go to court to argue to a court why then the case should be dismissed, and you write up something called a motion, either a motion to dismiss or something called a motion for summary judgment. So what you're doing is you're writing a piece of paper to a court, probably around 25 pages long, explaining to a judge what the law is, what the facts are in this case, and why the judge should then dismiss that particular cause of action based on pre-existing law. So that's a very persuasive bit of writing. It's not objective writing as the letter to, or the memo to the client would have been. Then I might be called in front of a judge to argue that case. So I may go to a courtroom and argue just before a judge. We argue simply the motion to dismiss. I explain to the judge why the case should be dismissed, and the opposing attorney, the attorney for the woman with Prader-Willi syndrome, responds to my legal arguments with his own legal arguments. Very often today, however, this is why we don't go to court that often, judges will decide that they can just read the two briefs and decide the case without oral argument. So when we think about attorneys going to court, arguing in front of a jury, that rarely happens because we like to settle cases, and the reason we like to settle cases is because it's a lot cheaper for the client. I can't remember how much they billed me out every hour, how much my clients paid me for hourly fees. I think it was around $150 an hour. So it's going to be very expensive for me to try a case. I have to prepare for the case. I have to actually argue the case in front of a jury, get a jury together, etc. And so you can see why this would be very expensive for a client, and then why the reason why the client may just decide to pay money, or the reason why the client would hope that we would win a motion to dismiss. So most lawyers are like me. Most lawyers never try a criminal case. Most lawyers are civil lawyers like me. Our clients are not criminals. Well, some people would say they are. But they're not criminals. They're not criminal defendants. They're corporations or other entities that find themselves, for some reason, in the court system. Okay, so how does science fit in? There's a little bit, I explained a little bit about Prader-Willi syndrome then as one of the examples, but let me tell you about a few other cases that I handled. When I was in Washington, one of the, my big clients was the elevator and escalator company that handled all the elevators and escalators in the Washington, D.C. subway system. So anytime anybody got injured on the Washington, D.C. subway system, on an elevator or an escalator, I would defend the company. If our company was brought in as a defendant, and generally it was, the reason why it was is because as a lawyer, you want to cast your net as wide as possible and bring in all the possible defendants. So anytime, even though my company was just maintain the elevators and escalators, nonetheless it would be called in an awful lot on these sorts of cases because they're casting their net pretty wide, even though they might think that they slipped and fell on some oily liquid would be the case I would handle often, but even if they thought that they had slipped on something like soda pop. So those are my cases. How does science fit in? Science fits in this way. I had to figure out then the general way escalators and elevators worked. and the science behind them. So I remember when I was first hired by the firm, having to understand by talking with an engineer at the company how the process worked, how escalators worked, how elevators worked. And that included things like torque, the reason why when an escalator stops suddenly, and they do this occasionally, why someone may or may not be injured, how they would be affected standing up if the escalator stopped suddenly, the difference between that and whether or not they're holding onto the handrail. So those sorts of questions I had to understand and go about doing my legal work after understanding that. I also had to understand the physics behind an elevator's hard stop. And what that means is that if the elevator also stops suddenly, people will fall, and the reason why that happened. So it was really important for me to understand this so that I could explain to the judge the reason why my client was not liable under the circumstances. So the science of it became very important. This is another way science was involved in my practice. How many of you have used a jetway, something called a jetway, to get to an airplane? A jetway is that contraption that you walk through from the airport to the airplane. We had a client in West Virginia who came up with a brilliant idea a few years back, and that is that jetways should have heat and air conditioning. No one before had come up with a way, for some reason, of heating and air conditioning a jetway. And so he created this. He invented this contraption that airports could then buy and heat or air condition the jetway. He thought it was a fantastic idea, and so he brought his idea to, I think, Borg Warner. And I can't remember, so I don't want to defame Borg Warner here. I can't remember precisely which company it was. But he brought his idea to Borg Warner, and he showed it to Borg Warner. Borg Warner took a look at it and said, you know what, good try, but we're not interested. You can take your invention and go about your merry way. Wasn't he surprised when approximately a month later, Borg Warner announced that they had come up with a contraption that heated and air conditioned jetways. And so he called my law firm and he wanted to sue. And he wanted to sue on intellectual property grounds, meaning that this was his invention, he had patented his invention, and he then believed that Borg Warner had stolen his idea. We then, we were unable to reach a settlement, and I came into the case later. I came into the case when it was on appeal. We were unable to reach settlement, and so we tried the case in front of a judge. And often you'll do that in science-related cases because the information is just so precisely scientific. You don't want a jury of regular people trying to understand how contraptions, how inventions are similar. So you want a judge to understand it, and you're going to hopefully count on a judge to decide the case in the correct way. Well, the judge was horrified at this story. And the judge gave our client the largest the largest bench award, the largest judge award ever in the history of West Virginia for any case. And I think it was around $25 million. So it was huge, a huge case. But that's an example then of an intellectual property science-related case. You have to compare designs and blueprints and understand the intricacies of a particular invention. You have to interview and understand experts involving those inventions. And when I say interview, what do I mean? Before a case goes to trial, or before you can file a motion to try to get rid of the case early, you actually want to interview experts on both sides. So someone like me would have to then interview the expert, Borg Warner's expert, about why he believed, or she believed, that the contraption that Borg Warner had created was dissimilar completely from our client's contraption. So that's what, when I say interview, I mean depose, and you're under oath at the time. So you have to understand experts. You also have to communicate with the inventor. So the inventor then understands his invention completely, mechanically and in every other way. You have to then communicate with him on a level that you look like an idiot, which is sometimes near impossible when it's a really intricate issue. So you have to communicate with the inventor and then make arguments that are understandable to a judge who probably has no science background. And so you have to not only be able to communicate with the inventor, you also have to be able to communicate with a judge when you argue and write up one of these motions to dismiss or a motion for summary judgment. You also might have to make those arguments understandable to a jury if you go to court, but again, it's very rare that you would go to court. Another one of my cases involved the trans man who claimed that he had received HIV from a blood transfusion, and the blood was supplied by the American Red Cross. So my client was the American Red Cross, and I had to then come to understand why it was scientifically impossible for the plaintiff in the case to have gotten HIV from our blood transfusion. And I had to understand then when HIV is testable in blood and how long it takes for symptoms to manifest themselves. So this was pretty early on in the AIDS epidemic, and that was then something I had to work with. I had to understand the science behind HIV and its transmission. I had to interview, depose doctors regarding HIV, AIDS, and transmission, and the ability to understand all of the above to a judge. What's interesting in the case is that we actually succeeded writing a motion to dismiss, so I got rid of this case really early based on the science of the case. So the science of the case is what got me out, or got our client out of this case, because I was able to explain to a judge the reason why it would be impossible for this particular fellow to have gotten HIV from the blood donor. Okay, other science-related legal matters. Some of these are going to be common to you. You're going to know about these things. DNA evidence in criminal cases, right? Accident reconstruction. How would the two vehicles hit, and at what point, or what would happen then? Asbestos cancer-related deaths. So how does asbestos work in the lungs, and why do people get sick from that? Pollution issues and health-related injuries. Trade secrets, and whether a particular machine's components are truly secret. Abortion and fetus viability. A lot of science in Roe versus Wade. If you read Roe versus Wade, there's a lot of science in there. By lethal injection. Same thing in the recent Supreme Court case involving cruel and unusual punishment and the chemistry involved in those medicines that are given to people on death row. Repressed memory. Whether then repressed memories should be used at trial, the validity of testimony under hypnosis, the validity of child testimony. Nearly 700 cases use the phrase the law of physics in some way. So that means more than 7 cases talk about the law of physics, that precise phrase in some way. These reported cases in the law books, and many, many more than 3,000 mention law and science in the same sentence. So, is a typical lawyer prepared for such work, that work where law and science intersect? Absolutely not. Probably there are people in here who want to become lawyers, and like me, you probably don't take many science courses. So you don't take many science courses in college, and then you go on to law school, and what do you take? You take these classes to start. You take property law, and what property law looks at is property law looks at the boundaries of a piece of property, for example, and whether someone who's walked across that piece of property for a very long time has earned the right to continue to walk across that piece of property for forever, and those sorts of issues. You take criminal law. What does first-degree murder mean? How is first-degree murder defined? Civil procedure law. How long do I have to file a response to a motion to dismiss? Is it 45 days? Is it 25 days? How long do I have? Constitutional law, a little bit of First Amendment, and beyond that, some other issues like states' rights. Criminal procedure, issues like the Miranda warning, legal research and writing, how to write up things to a judge, to a client, because the way we write as lawyers is very, very different from the way we learn to write in our undergraduate work. In second and third year, you have a little bit more of a chance to tailor your courses, and I'll talk about that in just a minute. But really, there's no ability for you to focus in more exclusively on science in law school. Therefore, there's a bit of a disconnect, I think, between law and that is that disconnect. Well, there's a book out that calls it a culture clash, that the two cultures, the law culture and the science culture, are clashing, and how difficult it is for the two groups to understand each other. One court called the area where science and law intersect the twilight zone. So it's an area where probably the scientists in here don't know very much about law, and when I get a science case, or when I got a science case assigned to me, I would certainly have to do much work on trying to understand it a lot better. A New York State court writes this about the disconnect between law and science. A famous scholar's concept of two cultures appears applicable to the relationship between law and science. Between jurists at one pole and scientists at the other, there may be equally a gulf of mutual incomprehension. And so that's the problem. Law is pretty convoluted, and of course so is science for those of us who don't know much about it, and therein lies the problem. So let me give you some, I think, really interesting examples of the way science has moved forward, and whether those moves forward should be used in a legal sense. And a great example is brain scans. A couple of weeks ago at the law school, a scholar named Tennille Brown presented a paper she's calling Through a Scanner Darkly. And so she looked at brain scans, which is a very, very new idea in law. How can we use brain scans in a case? A New York jury instruction, this is the instruction that's read to all jurors in an intent case. This is what it says. And what is intent? Intent is that I have to actually intend to hit you in order for you to claim that I've battered you. If I just accidentally brush up against you, you can't sue battery because it was an accident. So I have to formulate intent. Intent is basically a subjective element, that is the operation of a person's mind. However, Since we cannot x-ray a person's mind to determine what he is thinking, you may infer a person's intent by his acts or words or both. Her point is that this is becoming not precisely accurate because of scans. And brain scans may, in fact, help us to understand whether or not the person, the defendant in a criminal case, could formulate the intent to commit a particular crime. And this is through something called functional MRI, brain imaging. Okay, in science, as I understand it from this paper, functional MRI may soon be catapulted into the true study of brain activity and organization. It can be used, some scientists say, to determine the capacity for intent. And I already explained what capacity for intent means. And its uses could expand far beyond that. Is this a valid scientific tool? I assume everyone in here would say absolutely. What a wonderful thing to be able to look at the brain in that way. The law would ask this: is the information more prejudicial than probative? So we don't allow any bit of evidence in. We take a look at the evidence, the piece of evidence, and we say, if it's prejudicial to the person, let's say in a criminal case, if it's prejudicial, more prejudicial than probative, then we're not going to allow it in. So when you see a criminal case on court TV, for example, or what used to be court TV, there's much evidence that hasn't been introduced because the judge has found the evidence more prejudicial than probative. What would that be? That would be, for example, someone who committed bank robberies in the past is now on trial for murder. Should the jury hear about those bank robberies in the past where no one was hurt? A court might decide that that was more prejudicial than probative and not allow that evidence in, and so you as a jury would never hear about it. Who will be the expert to explain the images to a jury? Can the images then be used to determine guilt as much as innocence? Studies have shown that juries are excited about brain scans. If you ask people, if you give people a set of facts and you explain the facts, they may decide, 25% of them may decide to convict. If you put in one line about a brain scan helped support this, then it moves up to like 70-80% conviction. Just that simple word. So that's the reason why this is very important. Brain scans have been used already. This was a case, it wasn't a successful use of a brain scan. This was decided in 2008, so it can show you how this is very cutting edge, at least in law. A brain scan of a murder defendant showed a promality in the frontal lobe. The frontal lobe directs judgment, regulation of impulses. In this case, an expert had testified that the brain scan showed a big hole in that area, and because the defendant had also had alcohol, so it also consumed alcohol before he went out drunk driving and killed someone, that he was incapable of formulating the intent for second-degree murder, the intention to go out and kill someone, or for there to be a reasonable likelihood that he would kill someone. The jury convicted him anyway, but what was interesting is that the court focused a lot on that brain scan evidence, and when a court does that, then other courts will very likely do the same. So what sorts of questions are we left with? Can the prosecution call for a brain scan to prove intent or to disprove a defense claim about limited capacity? Think about that. Could brain scans someday become like fingerprints? We're arrested, we take a brain scan so that we know what you're thinking or the way your brain is functioning at that particular point of arrest. Could brain scans be required of victims in an attempt to show that they consented to a particular act? Think about that in rape cases. Should brain scans of the plaintiff in a civil case be used to prove or disprove a claim of emotional harm? Oftentimes plaintiffs will say, oh, I've been emotionally by the fact that the elevator stopped suddenly. I've suffered emotional distress from this. If we can scan the brain someday for that, should that be used, and what would be valid enough reasons so that a court would order a brain scan over objections. Okay, so that's a look at brain scans. This is another area. Now, I don't want anybody to say anything. Don't say anything, okay? I don't want anybody to say anything from here until the time we're done watching this. Some of you may have seen this before. And so it's very important to be quiet during this time when I show you this video. I'm going to show you a video of people passing a basketball. Half of the people are going to be dressed in black. The other half of the people are going to be dressed in white. What you have to do is you have to count the number of times someone wearing white passes the ball. Okay, is everybody clear on what the task is? So watch for the number of times someone wearing white passes the basketball. They're all going to be moving around. Okay, you ready? Please don't say anything or make any sort of noises during the video. It's very short. Let's count the number of times someone wearing white passes the basketball. Okay, how many times was it? Yeah, what? 14. Okay, so the basketball, did anybody else count different for 14? Did you count 13? Okay, 2 13s. Any other? 12? Okay. Did anybody notice anything unusual about this videotape? Yeah. Okay, there is a person dressed as a gorilla who enters the video and who exits the video. How many of you did not see the gorilla? Please raise your hand proudly if you did not see the gorilla. Okay. Okay, does everybody see that? Let's go ahead and watch this again, shall we? So that you believe me, okay? You ready? Let's watch it. Here he comes. Here he beats. And there he leaves. Okay? This is the same videotape. Approximately 50% of people do not see the gorilla. Okay? Which I think is fascinating. And I put some still frames of the gorilla here just in case it didn't work, so I could explain it to you. But what's so fascinating about this, in a legal sense, is scientific research, right? Does this mean now that all eyewitness testimony is suspect? You know, consider that. We count so much on eyewitness testimony, right? And when people testify, I saw that person do this. I guarantee you that if you, who did not see the gorilla, and again, 50% of people don't see the gorilla, my husband didn't see the gorilla, I knew about the gorilla beforehand, and it really is sad to me that I knew about it, so I can't tell you what myself, my husband didn't see it, and my 2 kids didn't see the gorilla. So 50% of people don't see it. If you, who didn't see the gorilla, had been called to testify about what you saw, your focus would be on the number of times someone wearing white passed the ball. If the attorney on the other side said, how about the gorilla? Was there a gorilla? You would say, what? No, there was no actually was. This is research done by Dan Simons at the university, and it's wonderful. It's been on Dateline before, so really interesting, and I so appreciate him letting me use this in this presentation today. The problem is, of course, once it aired on Dateline, who called Dan Simons immediately? Defense attorneys, criminal defense attorneys. How wonderful to get someone like Dan Simons to come on as an expert and to say, oh, it's possible that the gorilla actually was there at the car accident when the car accident happened, and you just didn't see it. So how your eyewitness testimony? And so consider these sorts of questions in the future. Should we allow experts like Simons to tell with testimony cases, motorcycle accidents, criminal cases, that the person accused or the witness who is testifying may not have seen what he or she thought she did? This science could transform criminal law, because criminal law standard is, in order for you to be convicted, you have to be convicted beyond a reasonable doubt. And would evidence like this, would reason like this then, help prove that there, juries are confused about reasonable doubt anyway, and what reasonable doubt means, and so this is a real concern. When should we allow testimony about research like this during a trial? Okay, so why should we care about this twilight zone, this sort of intersect between law and science? If law misunderstands science or uses it incorrectly, scientific progress will be affected. The disconnect starts with deciding who is expert enough to testify in science cases. Okay, so you scientists in here, consider this. What does it take to have an opinion accepted as expert within the scientific community? What does it take before someone can be recognized or someone can call himself or herself an expert in science? And you'll probably answer something like this. It takes solid research, publication, peer review of those publications, peer review of the research, and a foundation of science built on accepted technique. It takes to have an opinion accepted as an expert, to be accepted as an expert in a courtroom. Well, the Supreme Court decided this case recently, and here's what the Supreme Court said: not much. Who has some sort of training in the area can be accepted. We're going to leave it up to the jury to then decide how much we put on that particular expert testimony. The Supreme Court decided explicitly that an expert opinion does not have to be generally accepted as reliable as a precondition to acceptance in a trial. So even though we have these incredibly high standards in science, in law it's like free-for-all. You want to testify? Sure, come on in as an expert. And testify. When I say quacks can testify, that's not precisely right, but you get the idea. This means that there need be no scientific or scientifically vetted standard for expert testimony and evidence in law, other than a very cursory one. So a judge will just look to see, does the person have some sort of background in this, and if so, that's going to be okay. And we should leave it up to the jury to decide how much weight to give the testimony from this so-called expert. So this is the way courts have decided some cases that I find troubling when we think about science and law. And those students in here, and certainly those who work in science, can, I think, understand this. There was a case involving a young scholar who sued her mentor for copyright violation. And she sued the mentor for copyright violation because he was going to present a paper at a conference in which he used much of their research. He credited her as well for the research within the paper, but he himself was going to present the paper and had himself listed as the sole author. She sued for copyright violation. The court found that she had a valid claim. So the court said that, this is, it's unfair for him to have written a paper in this way and not have acknowledged her on the title page as a co-author, even though she was acknowledged within the paper as having done part of the work that he did as well. So how might that affect collaborative work between mentors and mentees in science? Also, courts and scholarly presentations. There was a case recently decided about patent law, and a researcher for a university went to a scholarly meeting and presented her findings on a poster board at 2 separate scientific meetings. She then attempted, after getting some input from people, she attempted to get her research, what she found out it was some sort of soy in cereal, patented. And the patent board said, sorry, you presented your information at a scholarly conference. You shared your ideas with other people. You don't get a patent. Now, the court said that had she gotten waivers from everyone, promises of confidentiality from everyone at the scientific conference, and if you attend these things, you know how massive they are, then she would have been able to get a patent, but not then without it. What does that do for scholarly presentations and sharing of research early on within science? And then courts and IP, this will just give you how courts are protecting intellectual property more, and how that protection of intellectual property, like patents, like ideas, will then affect the future of research. There was a scholar who used a breast cancer gene at UPenn in research. Another university had licensed that discovery. It was discovered by a professor at this other university. The university then, the license belonged to the university, because scientists here generally who create something, it will belong to the university as opposed to the scientist himself or herself. So, the university sold the gene to a profit-making company, and then the company threatened the scholar with a lawsuit for violating the patent by doing research. And so imagine that, to have that threat of litigation looming over you as you do research for the public good. Okay, so I will end by just talking very quickly about the intersection of law and science and how you might become a lawyer who specializes in this. By the way, those of you who are not interested in this at all, you could also perhaps testify as an expert witness. And I'm not saying that because the standard is so low. Sorry. What I'm saying that for is that if you're a scientist with a good reputation, you can make an awful lot of money by testifying at trial. Okay. School basis, how to get in. You have to have an undergraduate major. It can be anything. In fact, science majors are more impressive to law school than political science majors, because political science majors, quite frankly, are a dime a dozen, you know, and we're interested in getting majors with more experience. You have to have good grades, of course. You have to have activities. You have to have letters of recommendation from your professors. You have to watch out for what I like to call undergraduate shenanigans. What does that mean? That means doing certain things in public. You get arrested for something like that, the law schools want to know about that arrest, and so therefore you will have to disclose any arrest, and many law schools will not let you in if you have been arrested for anything. You have to take the law school admissions test, which focuses on analytical skills and reading comprehension. Somebody puts together the numbers, both your undergraduate grades and the LSAT, and comes up with a number to try to get you into law school. And there's a program here and at other universities where you can get into law school actually as a junior and not take the law school admission test if you have good enough grades. Basic design coursework, if you want to focus your law degree in a particular area, generally we don't do this, but you can take intellectual property law courses. There are multiple intellectual property law courses, environmental law, patent law, forensics some schools are offering. You can work on journals that focus on these sorts of things. You get joint degree programs in, for example, get a JD, a law degree, and a master's in chemistry. You can work during the summer at law firms that specialize in this sort of thing. And you can also clerk at the Federal Circuit in Washington, D.C. The Federal Circuit is an appellate court that focuses exclusively on things like patent and intellectual property law. So it's an exciting place for my students to work who have some sort of background in science. After you get out of law school, what do you have to do? You have to be admitted to the bar. You have to take a bar exam. You have to take the multi-state professional responsibility exam. You can waive into other bars, so whatever states you want to practice in, you generally have to take that particular state's bar so that you prove to the courts that you know enough about that state's law. For those of you who have a science background, and a number of my law students do this, they take the patent bar exam. And you do that in order to represent clients before the U.S. Patent Office. It tests procedures, ethics, related statutes and regulations. It's very difficult. Only 52% pass. So it's a really tough exam. Those people also have to have a background in physics, engineering, and other science-related degrees. But lawyers in regular firms, as I explained to you, also get science-related courses. Lawyers work an awful lot. We have to have, generally at big firms, at least 2,100 billable hours a year. What does that mean? That means that every hour I work, I have to bill someone. So when I worked in Washington, D.C., and I took the train into D.C., I would work on the train so that my hours spent on the train could be billed to a client. If a client gets a bill from me and I spent 10 hours trying to figure out the Prater-Willi case legally, the client doesn't want to pay that. The client will only pay 5 hours worth of that. That means 10 hours become 5 hours for billable hours. So it's not just the time you spend, it's the time that the client is willing to pay for you to spend on a particular issue. So even though we have to spend 2,100 hours, billable hours, we actually spend much more time at work, especially starting out, because clients aren't going to pay for all those hours. It's a lot of work, but there's great economic satisfaction if you can find time to spend the money. Many of my law students getting out, first year out of law school, zero experience other than during the summers and law classes, make $135,000, plus signing bonuses of around $20,000. So it's very, very lucrative. People who have engineering backgrounds and science backgrounds and who go to work in intellectual property, science-related law firms actually do even better than that. So when you're a member of the patent bar, your income actually goes up, and they do very well, by the way. Those people with science-related degrees do very well, in my experience, both in law school and when on the job market. So I have intrigued you enough so that you find yourself in court, not as a defendant or a plaintiff, but working in science and law sometime. So thank you all.